On the record in the matter of the people of the state of Michigan versus Rashad Trice, file number 23-02089 FY, counsel appearance.
Morning, Your Honor. Ailish Gallagher on behalf of the people.
Your Honor, good morning. My name is Keith Watson. I'm the public defender. I'm here today on behalf of Rashad Trice. He appears remotely from the Oswego County Jail.
Today was the date that was originally scheduled for a preliminary examination. I said I would treat today as another probable cause conference because the Attorney General's office was planning to issue charges for the homicide. Are they still doing that?
We are waiting on, we are waiting on additional reports, Your Honor. And that is why it's my understanding that the defendant is going to waive his 21 days today. And we would both ask that the court set this out for an examination date. And I will be in contact with Mr. Watson regarding any kind of update on the case in the interim.
Oh, and you've already discussed with your client the 21 days.
Yes, I have, Your Honor, and this would require a waiver of the 21 days. I believe he's prepared to do that.
Okay. Mr. Trice, can you hear me?
Yeah.
Okay, you have the right to have a preliminary examination in this file within 21 days of the date of your arraignment. You were arraigned on this matter back on July 5th, 2023. Do you understand that right, sir? Can you hear me?
Yes.
Okay, did you hear my question?
Yes.
Okay, I didn't hear a response.
I'll say yes.
Okay, very good. Okay, so are you willing to waive the 21-day timeline due to the fact that there are new charges that are pending and the Attorney General is still waiting on some reports?
Yes.
Anybody threatening you to get you to waive the timeline?
No.
Any promises being made to you in exchange for waiving the timeline?
No.
Okay. We'll reset this matter. How much time, Ms. Gallagher?
I believe we did get a date, Your Honor, that worked for all parties in the court. It was September 20th at 9 a.m.
So this matter will continue to exam on September 20th at 9 o'clock in the morning. Any additional matters for the record today?
None from the people. Thank you, Your Honor.
Nothing further from the defense. Thank you.
Thank you. You're all set, Mr. Trice. On the record in the matter of the people of the state of Michigan versus Kyle Joseph Quimby. File number is 23-00969 FY, counsel here.
Thank you, Your Honor. John Coltrane on behalf of the people.
Good morning, Your Honor. Attorney Derek Ketchert, also public defender on behalf of Mr. Quimby, who is standing to my left.
Your Honor, at this time, the people are unable to proceed and make their burden lack of a witness.
At this time, the defense would ask for to dismiss the case as the prosecutor is not prepared to proceed. Obviously, if that position changes when the alleged victim or other witnesses are appear in the future, he could reissue the case at that time.
Okay, this matter will be dismissed without prejudice. You understand your rights as it relates to without prejudice, sir?
Yes.
Okay, do you have any questions at this time?
No.
I'll get you a copy of the Denali. You'll be all set, okay?
Thank you.
Thank you, Your Honor.
You're welcome. On the record in the matter of the people of the state of Michigan versus Keith Wimberly, file number 23-01411. Appearance for the record.
Thank you, Your Honors. Assistant Public Defender Sarah Donnelly on behalf of the defendant Keith Wimberly, who is appearing separately by video.
Okay. We having a restitution hearing on this?
Your Honor, I'm not sure if, there was nothing provided to me for proofs, and I don't know if there's a prosecutor that was going to have someone here for a restitution hearing. It's my understanding, without any notice, I wasn't expecting anyone.
Restitutions.
Okay, the prosecutor indicates that no one's appeared, they won't be holding a restitution hearing. So, let's see. I do have what appears to be a victim impact statement. The victim is not present though, correct? Is there a victim here on this matter?
Not here.
Okay. Okay, Ms. Donnelly, you can make allocution.
Thank you, Your Honor. Mr. Wimberly is about halfway through, or a little over halfway through, a 3-month stay at TRICAP. He is on felony probation in Eaton County through Judge Mauer. His out date is September 5th. He is taking his medications. He has significant mental health issues. I believe it's either, I can't remember. I'm sorry if I apologize, Mr. Wimberly, it's schizoaffective or schizophrenia, but he is taking his medication. He is doing counseling and substance abuse classes. He's also working on his GED, and he's very happy where he is. It seems like he's in a good, better place now. If he wants to make allocution and apologize and let the court know how he feels too, I'd encourage him to. But Your Honor, he will live with his mother after TRICAP. I know that she tried to appear by Zoom, but I hope she's watching on YouTube. And he will continue on probation in Eaton County. So at this time, Your Honor, we're asking if any discretionary could be waived. That just, I believe he does, if any possibility time served, I do believe he did like at least a night. Thank you, Your Honor.
Wimberly, did you want to make a statement for yourself today?
Sorry. It'll never happen again. And trying to look forward to do better.
Okay, you need to stay on your medication if you want to do better. You understand that?
Yes. And stay
You're
off
already
drugs.
under- Yes, and stay off drugs for sure. You're already under a term of probation in another court, and you were sentenced to TRICAP. I think the issues or the underlying issues are being properly addressed through that court supervision. I'm not going to order any additional supervision or jail time at this time. I'll credit you time served. There is statutory fines that must be assessed. It's a $75 crime victim rights fee plus a $50 state minimum cost that also must be assessed. And I'll refer that to collections. Do you have any questions?
No.
Okay. Any additional matters for the record today, counsel?
No, Your Honor.
No, for defense, thank you.
You're all set, Mr. Wimberly.
All right, thank you.
You're welcome. Okay. Mr. Carter, you have Ms. Wiggins?
Yeah.
On the record in the matter of the people of the state of Michigan versus Tiffany Wiggins in file number 23-00022. Appearance, please.
Your Honor, Bill Coltrader on behalf of the people. And sorry, Your Honor, I have a letter here from the biological father who's presented to me today, and he is in the court.
He is present. Okay.
Quote, Your Honor, I don't know if you consider that or
Is this a letter that he wants to read or he wants me to read it?
I don't have to.
Okay.
There is one in there, I believe, from the grandmother too, but it is unsigned. Just a copy. Okay. So just the one statement, Your Honor.
Are both these from you, sir? It's up two different handwritings.
The one written in print is from me and the one written in cursive is from my mom.
Okay, so,
But they're both the same thing.
They're identical.
Got it. Okay. Yeah, they're the same one.
Sure.
Yes. Okay, I do have a pre-sentence report and recommendation. The report was prepared back on July 14th. Did you get a copy of that, Mr. Purdy?
I did, Your Honor.
Okay, any reasons to make corrections, updates, or deletions?
Yes, the update would be on my client's basic information portion. The very first page, her phone number has changed.
Okay,
517 894 1237.
any other changes?
On the next page, the health data, the current health problem / illness. Obviously, this was filled out back in May, but her pregnancy is still continuing, so she's further along with 6 weeks. 13 weeks. Pregnant.
Thank you. Okay, any additional updates, corrections, or deletions?
None that I'm aware of.
I don't think he realized it was two-sided. Okay. Did you get, I want him to give them a copy of the letter, because I'm not going to read it into the record just because of the
I
minor.
did share that.
Oh, they were already provided a
I
copy?
My
Okay,
client has not,
Thank
but I
you.
would like it.
okay, very good. If no other changes, you can make allocution.
Thank you, Your Honor. Stands before you is Ms. Wiggins, who is quite embarrassed for her actions in this matter. She makes no excuse whatsoever for this, but as a backstory behind this, she was raised in a very strict military family where the children are often defeated when they got in trouble. Again, I'm not making excuses. I'm just giving the court backstories because obviously what has happened in this situation is wrong. I believe that perhaps this was learned behavior because of her background. She realizes this is obviously an issue. She's making appropriate steps to correct this. She realizes that perhaps this is a cycle thing that she wants to break the cycle of. She's embarrassed that she has harmed her child in this way. She understands and she's learning to understand there's an appropriate way to discipline a child. She has stepped in with CPS and has cooperated fully and is substantially benefiting from CPS's recommendations. She's doing counseling through parenting classes, through Families First. She's in anger management. These are things in which she has involved herself in. I also see that the recommendation indicates no contact with the victim, and I as the court is aware, I did read that letter prior to coming going on the record here, but I'm also well aware that the family has already gone through some custody issues, and that court has heard these allegations and what should have. And it's my understanding that the father does have full custody now, and mom has been granted supervised visitation. I'd ask the court that to follow the recommendation. I'd ask the court to lead contact with the victim Daisy up to the family court that has more resources and more background with the family, and just order her to comply with all rules, all judgment of custody and CPS recommendations. It also asked for to submit random PBTs. She is pregnant. She does not drink. Alcohol and drugs have never been an issue here. I'd ask the court to consider not ordering that, but upon reasonable suspicion. She constantly is meeting with CPS, with DHS inside her home on a weekly basis, and there have been no issues with alcohol or drug issues. Thank you.
Ms. Wiggins, you wish to speak?
Yes, I do want to apologize to the court for my action. I do understand they were wrong, and I am glad that I'm working heavy with CPS and the anger management program. And I also have a therapist as well to correct my behavior, to break the cycle of what I went through as a child.
When you as a child, you were punished, corporal punishment, is what you're saying?
Yes, both my parents, that was our punishment, getting the and I was the oldest. So that was normal for me.
And they use a blow dry cord?
I did not use a blow dry cord. That's the only thing I can say that I did not use. I only use an belt. That's what I was using.
Okay. Did your parents ever make you get on the floor to eat food? Oh, okay. That, I just only mentioned that because it was mentioned in a letter here. Oh, okay. So your allegations or your position is that you've only punished the child by using a belt? Was it this one time or was there another incident? How did custody get the word to the father, was it for this incident?
Yes, it was for this incident.
Well, the victim impact statement, you've read it, I'm sure,
No,
correct?
she has not. Like I said, I have read it and I disclosed to her summary of what was in the letter. So
Oh,
she
well,
wasn't prepared.
there's a stark difference as to the series of events and what took place, and what has been taking place, and the effect that it has caused on the child involved. The concern that I have is that uh, your attorney mentioned multiple times that you're embarrassed. I don't know that that translates into remorse, or that you, it doesn't translate to me into uh, remorse as it relates to the relationship you have with your child or the condition that your child is in. Embarrassment is self, that's about you. What about the child?
I was gonna say, I didn't personally use the word embarrassed.
I didn't say you did, I say your attorney, you didn't use anything, you didn't address that at all, and I gave you an opportunity to speak.
I do feel remorse. I do feel guilt and sorry for my actions and what the pain has caused.
I've read the pre-sentence report, the recommendation. I've also read now the victim impact statement and reviewed the prior criminal history. Did she get the warrant and 54B taken care of?
I'm sorry.
Did she get her warrant and 54B taken care of?
She was not aware of that until I brought that to her attention and I indicated that she needed to address that right away. She has her driver's license. She doesn't understand what it's from, but she'll definitely have that.
She may have a driver's license, but it might have a suspension on it, for failure to appear. Says here, there's a criminal bench warrant for failure to appear and pick up within 50 miles. Pull it off the record, let me get her driving record. Driving record too. You can have a seat. Are we running Richardson or Stahalan, do we know? Are we running Richardson or Stahalan?
I think I have on Staley, we have a witness here. Victim, I need to talk to her.
Okay. You can do that now unless you wanted to participate in the sentencing. I don't think it's.
I know that Wilson, I believe, received notice that full agent that he cut his tether off on Monday. But I do have.
Okay. Where'd they go? You can be seated. All right, this is suspended because of the warrant. Sorry? Looks like it's been a warrant status for a couple of years. It's 2021. This warrant is from 2021 anyways. Okay, so I reviewed, we're back on the record. I reviewed the pre-sentence report and the recommendation. I'm happy to hear that you are taking some measures to address the issues, including having counseling and some services for parenting. The request, I think, or the victim impact, the victim is requesting the maximum. I don't know that that's beneficial for you to sit in jail and not work on the issues and work on mending the relationship with your child. It sounds like the child's been placed in a environment now that's more conducive to her safety. Hopefully she's getting some counseling and she's getting the help she needs. But the ultimate goal, I'm sure, of Child Protective Services and then even of this court would be that there would be some reconciliation at some point, and that you can have a healthy, viable relationship with your daughter. Children need their mother, but daughters especially need a good, healthy, thriving relationship with their mother. Not to discount the relationship that they need with their father, but they definitely need, your daughter definitely needs you. She needs you to be able to be a positive force and discipline her in ways that are more positive. With that being said, I think a term of probation is appropriate. And so I will sentence you to probation. You'll be sentenced to a 12-month probation. While on probation, there is a $30 per month oversight fee that you're responsible for, okay?
Yes, Your Honor.
I'm not going to order a no contact order. You're gonna follow whatever CPS order is, okay?
Yes, Your Honor.
So if that's supervised visitation or otherwise, it's up to them. While on probation, you're not to engage in any assaultive or threatening behavior. You're not to purchase or possess firearms, ammunition, or weapons of any kind. You're not to use alcohol, marijuana, or a controlled substance while on probation. I recognize that you are currently pregnant. You're saying you don't drink at all?
Well, no, I mean, if I wasn't pregnant, I do have.
Okay, because you're not allowed to drink while on probation. And I recognize that's not an issue for you now. So I'm not gonna order that you to test while you're pregnant, because I think that's unnecessary. Otherwise, you would be responsible to test when you're not pregnant, if you're still on a term of probation. Do you understand that?
Yes, sir.
You're not to be in any bars or nightclubs. I do see that you do work at a bar and grill. Obviously, that's not an issue. You do need to maintain employment and provide verification of that while you're on probation. Gonna order that you participate in a 12-month, I'm sorry, 12, I'm sorry, that was not, you're gonna do 12 months probation, tells you that. You're going to participate in anger management. If you're already in anger management, you're gonna provide verification of that. Do you understand?
Yes.
You'll participate in any other program as recommended by probation. Do you have any questions?
No, no.
As to fines and costs, there's a $75 crime victim rights fee that will be assessed. There's a $50 state minimum cost. That's also going to be assessed. 12 months probation will be $360, just $30 per month. I don't see where there's restitution that's going to be ordered at this time. Restitution was not provided to pretrial services, and I think the victim impact statement says that all medical bills were paid for. That's accurate, sir? Okay, so there's no restitution ordered. I'll waive discretionary fines and costs at this time, so you'll just be paying oversight and then the statutory fines. For a total of $485. You'll make monthly payments on that, okay? Lastly, there's an advice of rights as to probation. It says that you have the right to request early discharge from probation. You have to complete the first 50% of what I've ordered you to do, and then you have to have had no violations within the 6 months prior to that, okay?
Yes.
You would make that request by using the early discharge probation form, and you would file a copy with the prosecution's office, and they would have 14 days to respond to that. If you need a hearing for that request, you do not have the right to court-appointed counsel. You would have to hire an attorney. Do you understand that? Do you have any questions about that, Ray? Any additional matters on this record?
No, Your Honor.
Okay, because you do have a warrant that requires a pickup within 50 miles, you are going to be taken into custody of the Lansing Police Department, okay?
I heard that until I started listening to so shocked. You guys even. I don't know. But I just want to come introduce myself and hopefully get it done. Yeah, I think so.
Launch for the other two films.
Yep.
Is that one of the requirements that he has to testify in front of you in the two other films?
No. Okay.
He sold a motorcycle to a friend of his,
Yeah.
Casey Schweitzer.
Yeah.
Facebook messages.
As soon as I know from these guys.
This is from Alan about it being out.
There's one other one.
Yeah, Bruce Galvin. So Bruce was the guy we talked to while they were here. And Bruce said, "Fix it, blah, blah, blah." So Kalamazoo, APA temporarily denied the warrants for Gowan and Schweitzer because it fits Fifth Amendment rights and knowing that we testified.
Yeah.
Schweitzer.
Got it.
So.
Just wait till we get these.
Right,
right.
No
We didn't have our
guarantee on that one. I think you know
Um,
that.
Right, right.
Then we don't have to hear any more
We're in the hallway.
conversations.
If we needed to.
Okay, let's see.
I'm gonna charge the guy. and-
Call her, said there's offers on both sides. So what's the talk?
No financial.
Stanley. House and jail, their attorneys, I talked to them and there's three offers on both. They're trying to-
Everybody's in jail, their attorneys have to talk. Isn't that what the probable cause conference is for? No? They be running the jail. What about Jackson? Jackson's not in jail.
He is sitting right over there.
Oh, where's his attorney? Milks was standing outside my door.
Did you talk to your attorney?
So he said he was gonna be sitting.
Well, don't tell me what he told you. I just want to.
Oh, no, yeah, I talked to him. He said he wasn't gonna be here.
You say he wasn't gonna be here.
Yeah, he said he was gonna send somebody. He said he had another person.
Milks is right there. He's in Flores' courtroom. Let's pull the pants up. Where is the actual file? It's a comfortable already. So let's. Following, we're not ready at 8:30. What's his name?
Mr. Yeah, Mr. Messer.
Oh, on the record in the matter of the people of the state of Michigan versus Rufus Messer, file number 23-00334. Council appearance.
Andrew Stevens on behalf of the people.
And Luke Goodrich from the Public Defender's Office here to represent Mr. Messer, who is standing tonight.
How are you, Mr. Messer?
I'm good. How about you?
I'm doing pretty good.
Nice to hear.
Okay, today's the date and the time that was set for preliminary examination. But my understanding is that there is a waiver to circuit court, is that correct?
Correct, Your Honor.
Yes, sir.
Is there an offer at all?
I extended one this morning. If Mr. Goodrich wants me to put it on the record, I'd be happy to. Otherwise, I'll sort of defer to his wishes.
Yeah, we would certainly like to have him place it on the record at this time.
Thank you, Your Honor. This morning, I extended an offer of a plea to flee and elude in the 4th degree, which is a 2-year felony. And then, of course, if upon successful plea and sentence, we would move to dismiss the underlying count.
Oh, sounds good. And so, Mr. Messer, you understand that you have the right to have a preliminary examination in this file in the district court.
Yes, ma'am.
You understand the purpose of the preliminary examination is to require the prosecution to meet their burden of probable cause. So they need to establish that they have sufficient probable cause that a crime was committed and probable cause sufficient to charge you with the crime. You understand that? You want to unconditionally waive your right to examination? Okay, anybody threatening you at all to get you to waive it? Any promises being made to you in exchange for you waiving your exam? Are you waiving it freely and voluntarily?
Yes, ma'am.
You understand that it's unconditional as to the waiver, so this matter will be bound over without a hearing here. You can't change your mind or say that you waived your right in lieu of a promise of some sort. You understand that? Okay. The bind over date is going to be August 2nd. You do not need to appear in court on August 2nd. That's the date they'll get the file from this court, okay?
Yes, ma'am.
Is he being held on something else?
Your Honor, he does have to get arraigned on misdemeanor warrants for a traffic matter this afternoon. But then that's the only thing that should hold him. This is just he is a PR bond. Then he has a matter in Eaton County.
They're holding him in Eaton, is that what?
Yes.
Oh, okay, sounds good. Okay. Bond will continue at the amount of 5,000 personal recognizance. Your next court date will be in pretrial. A pretrial at circuit court. Mr. Goodrich will be made aware of that, okay? Your number still ends in 3760?
Sure. If it isn't, I'll change it down.
Oh, okay, well, make sure the court and your attorney has your accurate contact information so you don't end up with a bench warrant. Okay, any additional matters for the record?
Nothing from the people. Thank you.
No, Your Honor, thank you.
You're all set. Is Mr. Richardson?
Yes, ma'am.
On the record in the matter, the people of the state of Michigan versus Savion Richardson, file number 23-01945, that's why, appearance please.
Thank you, Your Honor. Dale Coltrader on behalf of the people.
Good afternoon, good morning, Your Honor. Assistant Public Defender Stephen Feigelson, appearing on behalf of Mr. Richardson, who's seated to my right, Your Honor.
Okay, how are you, Mr. Richardson?
I'm doing well.
Okay, today's the date that was set for preliminary examination. If you have a plea sheet, it says that the people are offering for you, Mr. Richardson, to enter a guilty plea to the added count 2 of receiving and concealing $200 to $1,000 misdemeanor under NCL 750.535 for A, maximum penalty 1 year or $2,000 or 3 times the value, and the people will dismiss the remaining counts, and there's an agreement that you'll pay restitution. There's also a killabrew of sentencing to run concurrent with his sentence or your sentence before Judge Jamer. That's complete and accurate?
That's correct, Your Honor.
Okay, and that's the plea offer that you understood and want to take?
Yes, ma'am.
Okay, can you raise your right hand?
Do I gotta stand up?
No, you just raise your right hand, you're fine. You solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury.
Yes, Your Honor.
Okay, I have an advice of rights in the plea information sheet. It has today's date on it. Is that your signature?
Yes, Your Honor.
Could you read this document?
Well, I skimmed over it.
You
but
skimmed over it. Do you know what rights are on here?
Just the basic trial rights and things like that.
Oh, so you just signed it and you don't know what the rights that you're waiving. You just
Unfortunately.
giving up stuff, huh?
Yeah.
So you have a right in this matter to be represented by counsel. You are represented by counsel. That right's noted on here. Did you know that?
Yes, sir.
You have the right to plead guilty, plead not guilty, or stand mute. If you stand mute, we'll proceed to a trial in this matter. You understand that?
Yes, Your Honor.
Okay, and so you have the right in this matter to proceed to trial. At the time of trial, you enjoy the presumption of innocence. So you're innocent until proven guilty. Do you understand that?
Yes, Your Honor.
You have the right to have the prosecution prove each element of the charge being brought against you beyond a reasonable doubt at a trial. You have the right to see, hear, or question any of the witnesses in court that the prosecution calls against you. You have the right to call your own witnesses at a trial or present evidence at trial you believe further a defense to the charge being brought against you. You understand each of those rights?
Yes, Your Honor.
You want to give up all of those rights?
Yes, Your Honor.
Okay, you also have the right to remain silent and not have silence be used against you at trial. You recognize that as well?
Yes, Your Honor.
Okay, and so anybody making any promises to you or threats to you to get you to want to waive your rights today?
No, Your Honor.
Okay, and you are on probation already?
Parole.
You're on parole. Okay.
Yeah.
You understand that a guilty plea could result in a conviction that may have impact on that parole status? I assume you spoke with Mr. Feigelson about that already?
Yes, Your Honor.
Yes, we did.
Okay, great. And you understand that a guilty plea could result in a conviction that you may need to report to a future employer?
Yes.
It also can have impact on travel or immigration status you may be seeking. You understand that?
Yes, Your Honor.
Okay. And are you entering a guilty plea because you believe you're guilty?
Yes, Your Honor.
Okay, as to the added count 2 of receiving and concealing $200 to $1,000, do you plead guilty, not guilty, or stand mute?
I plead guilty.
Factual basis, please.
Yes, Your Honor. Mr. Richard, I want to turn your attention back to February 24th of this year. Were you at 1010 Knollwood Avenue in the city of Lansing?
Yes.
That's here in Ingham County, state of Michigan.
Yes.
And while there, you had just purchased a 2018 Dodge Durango, is that correct?
Yes.
And at some point in time, law enforcement comes in contact with you, is that correct?
Yes.
Because that vehicle was stolen, is that correct?
Yes.
And although you didn't participate in the stealing of the car, you had reason to believe or should have known that the person that you bought the car from had stolen the vehicle from somebody else. Is that correct?
Yeah.
And that reason would be, can you tell us why you thought you should have known it was stolen? Give you that belief.
I guess because the guy didn't have a tire, I should have known that was a big red flag that the car was stolen. I
You
thought
also,
it was gonna be-
you also didn't have plates either. Is that correct, Jennifer?
Yes.
I have no additional questions for Mr. Richards.
Any other questions?
No, Your Honor.
Court is satisfied with the factual basis. I'll accept your plea and find your plea to be made freely, voluntarily, and intelligently. Is he already under sentence before JMO?
He's not, Your Honor. He's going to be sentenced September, Your Honor.
He's gonna be sentenced September when?
September 20th.
Okay, we need to do that here. 28. This matter will be set for sentencing on September 28th at 8:30. You do need to meet with probation in this court so that they can provide the court with a pre-sentence report and recommendation, okay?
What time did you say on the 23rd?
8:30 in the morning. Note that in the file so that probation can get in touch with him while he's in custody to get his pre-sentence report taken care of. If you postpone between that time frame, you need to report to probation within 48 hours of your release, okay?
Yes, sir.
Do you have any questions? Okay, any additional matters for the record?
No, Your Honor, thank you.
Nothing, Your Honor.
You're all set, sir.
Thank you.
You're welcome. Mr. Suggs here?
I know he had something.
I think he's in front of the board.
Oh, okay. And then we did message. This is Perales that you have.
Yes, Your Honor, I think you're ready in a moment.
Who do you have?
Mr. Wilson and Mr. Jackson. Mr. Wilson is ready. And it'll be.
We'll be proceeding on.
We are gonna run up Mr. Jackson. Okay, Mr. Wilson is here. Okay.
Yes. I'm not sure about Stalen. Mr. Starks is.
For Judge Ward. Okay, on the record, in the matter that, I'm sorry?
May I approach him?
Oh, you may. On the record in the matter of the people of the state of Michigan versus Andrew Perales, file number 22-02266. Appearance, please.
Your Honor, Dale Coltrader on behalf of the people.
Good morning, Your Honor. Assistant Public Defender Stephen Feigelson appearing on behalf of Mr. Perales.
How are you, Mr. Perales?
Doing good, Your Honor. How are you?
I'm well, thank you.
Thank you.
Today's the date and time set for a preliminary examination, but there's a plea sheet. It says the people are offering Mr. Perales for you to plead guilty to an added count 2 of attempting, resisting, obstructing a misdemeanor, maximum penalty 1 year or $2,000 in fines. Do you understand that offer?
Yes, Your Honor.
Do you want to accept that offer today?
Yes, Your Honor.
Just raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
Yes, Your Honor.
Okay. You have an advice and rights and free information sheet.
Yes.
Looks like it says September. I can't really read the date, but is that your signature?
Yes, ma'am.
Okay, did you read this document?
I did.
You understand all the rights that are listed here?
Yes, Your Honor.
Do you have any questions about any of these rights?
No, Your Honor.
Okay, so you're willing to give up all of these rights in order to plead guilty to the count 2 of attempted resisting obstructing an officer?
Yes, Your Honor.
So that means you're gonna give up your right to the presumption of innocence. So you're innocent until proven guilty, and you have the right to require the prosecution to prove your guilt at a trial by proving each element of the charge being brought against you beyond a reasonable doubt. You want to give up that right?
Yes, Your Honor.
Okay, you have the right to remain silent at trial and not have silence be used to prove your guilt. You have the right to confront in court any of the prosecution's witnesses and cross-examine them. You have the right to call your own witnesses to court or present evidence that you believe would further a defense to the charge being brought against you. You want to give up those rights?
Yes, Your Honor.
Anybody making any promises to you today to get you to waive those rights?
No, Your Honor.
Has there been any threats made in exchange for you entering a guilty plea?
No, Your Honor.
Are you currently on probation or on parole?
I'm not, Your Honor.
You understand that a guilty plea could result in a conviction that may have impact on any travel or immigration status you may be seeking.
Yes, Your Honor.
A guilty plea can also have an impact on any job you may be seeking, or you may need to report a conviction to your current or future employer. You understand that?
Yes, Your Honor.
Or you're entering a guilty plea because you believe you're guilty?
Yes, Your Honor.
As to the added count 2 of attempted resist obstruct, are you pleading guilty, not guilty, or standing mute?
I'm guilty, Your Honor.
Actual basis.
Mr. Honor, Mr. Prowse, I want to turn your attention to August 25th of 2022. Were you at Wainwright and West Jolly Road?
Yes, yes, sir.
That's City of Lansing, Ingham County, State of Michigan.
Yes, sir.
And while there, you came into contact with law enforcement, is that correct?
Yes, sir.
And law enforcement had a lawful reason to chat with you, is that correct?
Yes, sir.
And you took some action to resist those officers. Can you tell me what you did?
I failed to obey.
And they gave you a lawful command. What kind of command did they give you?
To turn around and put my hands behind the back.
To arrest you?
Yes, to
basically?
arrest me, yes,
Okay.
yes, sir.
And you didn't comply with that request, is that correct?
Yes, sir.
You have no additional questions for Mr. Morales?
No question, Your Honor.
Are you satisfied with the factual basis? I'll accept your plea. Find your plea to be made freely, voluntarily, and intelligently. How long is he in custody on this?
He's been in custody on this for a week, Your Honor. How long was it, bro?
A week, this time I was in custody before, and since this incident occurred, I've been doing really good, Your Honor. I've been staying out of trouble. I've retained a job. I've got my daughter staying back with me. She's back in my life. I've been doing really good though.
Where are you working?
Myers Warehouse.
Oh.
Yep.
You wanna proceed to immediate sentencing? Any
Sure, Your Honor.
objection? Okay. You can make allocution.
Thank you, Your Honor. Mr. Morales, Your Honor, has done a lot of good things in the last year. He has his daughter back. He's employed. Your Honor, I'd ask for either fines and costs or a short period of probation.
Counsel?
Your Honor, whatever sentencing is, obviously, I'm gonna leave it up to the court. The only thing I would point out is this defendant was gone for a year, and it did start out as a felony. That's all.
Thank you. I'm gonna sentence him to 6 months probation. While on probation, you have the following conditions. You're not to engage in any assaultive or threatening behavior. You're not to use, purchase, or possess any alcohol or drugs without a prescription. need to maintain employment and provide evidence of that employment to your probation officer. Do you understand that?
Yes, Your Honor.
You have to be at any bars or any nightclubs. And you will be required to have random preliminary breath testing and or your analysis testing during that 6-month period. Do you understand that?
Yes, Your Honor.
Not to possess firearms or any other dangerous weapons while you're on probation. Do you have any questions so far?
No, Your Honor.
It's a $30 per month oversight fee that you will be responsible for while you're on probation. So a total of $180 there. There's a $75 crime victim rights fee that will be assessed, plus a $50 state minimum cost that will also be assessed. Waive discretionary fines and costs. A total of $305, which you'll make monthly payments on that, okay?
Yes, Your Honor.
There's an advice of rights as to probation, and the advice of rights is that you have the right to request early discharge from probation after you complete, in this case, 3 months of probation. As long as you don't have any violations within those 90 days preceding the request, you would make that request by getting the MC 512 form from probation. You would submit that request to probation and to prosecution. Prosecution has 14 days from the time of your request to respond to that request. If you're here, if that's up for hearing to address your request for early discharge, you have the right to hire an attorney to represent you. You do not have the right to court-appointed counsel if there's a hearing set for that purpose, okay?
Thank
Do you have any questions about that right?
No, Your Honor.
Okay. He's being held on this.
Nothing from the people, Your Honor.
He is being held this, but he also has a pending matter with the judge.
Very good. What's your the address on Holmes?
Yes, Your Honor.
Phone number ending in 0621?
Yes, Your Honor.
Okay. Any additional matters for the record?
None, Your Honor, thank you.
You need to make sure you report to probation within 24 hours of your release, okay?
Yes, Your Honor.
Thank you.
Nice seeing you, Your Honor.
Thank you. Have a good one.
See you tomorrow or next week.
We're already on Wilson. Mr. Knuckle, you're doing Wilson or?
Yes.
Okay. On the record in the matter of the people of the state of Michigan versus Devin Wilson, file number 23-01258.
Your Honor, Dale Coltrader on behalf of the people.
And Assistant Public Defender Scott Nichol on behalf of Mr. Wilson.
How are you, Mr. Wilson?
I'm good, Your Honor.
I'm well, thank you. Today's the date that's set for a preliminary examination, but I see that there was an offer for the defendant to plead guilty to an added count 2 of receiving and concealing 200 through 1,000. That's a misdemeanor with the maximum penalty of 1 year or $2,000 in fines. And the people would dismiss count 1 upon successful plea to count 2. There's a Killebrew, which is a sentencing agreement of no upfront jail. Is that a complete and accurate statement of the plea offer?
Yes, Your Honor.
You want to accept that offer?
Yes.
Raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury? Okay. There's an advice of rights and plea information sheet. It does have today's date on it. Is that your signature, sir?
Yes.
Did you read this document?
Yes.
You understand each of the rights listed here? Are you willing to give up all these rights in order to plead guilty? Okay, it means you're gonna give up your right to the presumption of innocence. So you're innocent until proven guilty. You have the right to require the prosecution to prove your guilt at a trial, and you have the right to a jury trial. At the time of trial, you have the right to have them prove each element of the charge being brought against you beyond a reasonable doubt. You understand that? You have the right to confront and cross-examine any other witnesses that they intend to call against you at trial. You have the right to call your own witnesses or present evidence that you believe further defense of the charge. You have the right to remain silent and not have silence be used against you. You understand all of those rights? And you want to give them all up today? Anybody threatening you to get you to waive your rights? Has there been any promises made to you in exchange for a guilty plea? Are you currently on probation or parole? On parole? You understand that a guilty plea could result in a violation of your parole status?
Yes.
Okay, who's already violated? Okay. And you understand that a guilty plea could result in the conviction that may have impact on travel or immigration status you may be seeking? And a guilty plea could also be something that you need to report to your current or future employer. You understand that? Okay. As to the added count 2 of receiving and concealing 200 to 1,000, do you plead guilty, not guilty, or stand mute? Okay, and are you pleading guilty because you believe you're guilty?
Yes.
Okay, can I have a factual basis?
Yes, Mr. Wilson. Back on August 20th of 2022, were you at 1241 Lathrop Street?
Yeah.
And there's that in the city of Lansing, Ingham County, state of Michigan?
Yeah.
And at that location, did you purchase a black and chrome Suzuki motorcycle from a Justin Branford? That's a friend of yours? And did you purchase that motorcycle from him for approximately $350?
Yeah.
And did you have reason at that time to suspect that that motorcycle was stolen?
No.
You understand you paid, did your friend have a title to the motorcycle?
No.
And do you have reason to believe the motorcycle might have been worth more than $350? So reason to believe that it was a stolen motorcycle, correct?
No.
Any questions from the prosecution?
No other factual basis questions?
Okay, the court is satisfied with the factual basis. I'll accept your plea. Find your plea to be made freely, voluntarily, and intelligently. This matter is set for sentencing July 20th. I'm sorry. It's set for sentencing on September 7th at 8:30 in the morning. When you leave here today, you need to go downstairs 1 floor to probation. They're gonna get you set up for a pre-sentence investigation. They're gonna provide me with a report with a recommendation as to how you ought to be sentenced, okay?
Just so the court's aware, this afternoon, Mr. Wilson is turning himself into Bear River to undergo 90 days of sobriety treatment, so he will need to appear for that.
6 months.
90 days inpatient, another 90 days outpatient treatment, and so he will need to appear for that sentencing via Zoom.
That's completely fine. You can appear via Zoom. You do have the Zoom instructions. That's the blue sheet there. Okay, and so you'll go and Mr. Baylor will escort you downstairs to probation so you can get set up for the interview, okay?
Okay, thank you.
No problem. Any additional matters for the record?
Nothing further to the record.
Nothing from the people, Your Honor.
Thank you,
Your
Your
Honor,
Honor.
I'm prepared to proceed on Mr. Jackson's case. I just need to release some officers on his last 3 days.
Okay, sounds good.
We will be proceeding victims on that case.
Okay. Is Mr. Milks not handling Jackson?
Oh, no, I'm handling the Jackson.
Okay.
Mr. Mills is in court in the third district.
You have standing arrest and search on the record.
on the record in the matter of the people of the state of Michigan versus Devontae Jackson, file number 23-01847.
Thank you, Your Honor. Dale Coltrader on behalf of the people.
And Assistant Public Defender Scott Nickel on behalf of Mr. Jackson, just present and standing.
Oh, Mr. Jackson, today's the date set for a preliminary examination. I believe we're ready to proceed. Are there any preliminary matters?
No, Your Honor, the people are ready to proceed. We will indicate ahead of time that we are going to proceed on this case.
Counsel, any preliminary matters?
No preliminary matter.
You can call your first witness.
Thank you, Your Honor.
There we go.
This time, Your Honor, people will call Officer Tara Brandon.
Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
Yes.
If you can have a seat, officer. You state your first and last name and spell both of them.
Tara Brandman, TaraBrandman.
You can proceed.
Thank you, Your Honor. Good morning, officer. I guess it's almost afternoon. Good morning. Where are you employed, officer?
City of Lansing,
And how long have you been employed there?
about 8 years.
And what is your function at the city of Lansing?
I'm a road patrol police officer,
Okay, and how long have you been on road patrol?
the whole 8 years.
Okay. I'm going to take your attention back to the day of June 14th, 2023. Were you working that day?
Yes,
What capacity were you working that day?
road patrol,
How were you dressed that day?
same way I'm currently dressed.
And were you in a squad car?
Yeah.
Fully marked?
Yes,
Did there come a point where your duties took you to a location of Cesar Chavez and Chestnut Street in the city of Lansing?
yes.
And what took you to that location?
We got a 911 call, I think more than one, for witnesses saying they were observing a male assaulting a female on the sidewalk.
Okay, that's why you were dispatched to that
Yes.
location. And that location is in the city of Lansing.
Yes,
I think I already asked that question. How long did it take you to get to that location at the time you were dispatched?
less than 5 minutes I was in the back.
Okay. When you arrived at that location, did you come into contact with anyone?
Yes,
And who was it that you came into contact with that day?
the victim in the street said, I apologize, I can't recall her name.
Okay. If I presented you your report, would that adequately refresh your recollection?
Yes.
If I could approach your
Sorry
honor.
about that. Yes,
And who was that person?
the victim, Alyssa Morris.
Okay. And did you come into contact with anybody else at that time?
Yes.
And do you remember that person?
I don't because I didn't take her official statement, but there were 2 witnesses on scene with her that my partner talked to.
You come into contact with the defendant at that location?
Yes, not at that time, but shortly after.
Now, when you came into contact with that individual who you described as Miss Morrison, could you describe her demeanor that day?
She was pretty upset. She was crying, her mascara was running down her face. She was kind of reluctant to give me information about what actually happened. She had visible injuries all over her body.
Could you describe some of those visible injuries?
Well, she was pretty banged up. She had scrapes and bruises pretty much head to toe, in varying sizes, shapes, and colors. The most notable ones were on her neck. Some abrasions and bruising that was starting on all, I think, 3 sides of her neck.
Was any medical treatment offered for that day?
Yes, multiple times.
Now, did she tell you who actually gave her those injuries that day?
Yeah.
And did you obtain information concerning the relationship between those parties?
Yes.
Okay. This time, Your Honor, people would seek to admit statements of Ms. Morris from the victim to this officer pursuant to 768.27C, and that all 5 requirements have been met. The statements were made about infliction of injury for medical treatment purposes. They were made at or near time of the infliction. I think the officer testified it took her 5 minutes to get there from the time of the report. These will involve, and I could elicit more testimony, like a domestic violence, a domestic relationship between those two. Also, under the circumstances, it would indicate their trustworthiness. It seemed like the officer indicated she was pretty upset. She was crying. She was shaking. She had injuries pretty much from head to toe, I think is what the officer said. The officer indicated she was fully dressed in her uniform. So I would seek to admit those statements at this time.
Okay, I think I need you to elicit some testimony about the nature of the relationship, because I don't think she's.
I didn't do that, but I could. At that time, I asked you if you understood the nature of that relationship. What was your understanding of the nature of that relationship at that time?
They were in a former dating relationship. They've been together a couple of years. They had broken up earlier this year. They have a child together, and she's currently pregnant with this child.
Okay. Then I would indicate, obviously, a child together, former dating relationship. So I would indicate this as a domestic relationship.
Any objection?
I would simply place just an objection to use of 27C. This is all hearsay testimony. Ms. Morris is not here to testify. I am, but ask the court not allow the prosecution to proceed without the complaining witness in the case.
Okay, the objection is overruled. The law currently provides for this testimony to enter under MCL 768.27C. You can proceed.
Thank you, Your Honor. Now, officer, what did Ms. Morris say happened to her that day?
She said that her and the accused defendant.
Can you speak up a little bit?
Yes, sorry. She said her and the defendant were in an argument because she is pregnant and she needed some help with the other child. And he was giving her a hard time about needing some rest. And so it got heated and then eventually became physical. She said they grabbed her several times. They ended up outside at some point and he was repeatedly punching her with a closed fist. She couldn't recall how exactly he got a hold of her. She knew she was on the ground at some point.
Did he indicate to you at any time that he had placed his hands around her neck?
Did she?
Yes.
No.
Did you observe marks around her neck at that time?
Yes.
Did you take photographs taken that day to memorialize what her condition was?
Yes. And during her initial statement, she did not say anything about the neck, but when I was asking my questions to evaluate the lethality factors in their domestic relationship, has he ever put his hands on your neck? She said yes today. So she had clarified afterwards.
So just to be clear, she did indicate that he put his hands around her neck.
Eventually, yeah, during the first part of the statement.
And she did indicate to you that she was pregnant that day.
Yes.
Did she at any point indicate to you that you knew she was pregnant?
Yes.
And at any point, did you have an opportunity to question the defendant?
Yes.
And you know who that defendant is?
Yes.
And what is his name?
Michael Jackson.
And you see him in this courtroom today? Can you point out something he's wearing?
Yes, he's wearing a black t-shirt.
Okay. And sitting,
Yes, sitting.
Your Honor, let the record reflect that she has identified Mr. Jackson.
Any objection?
No objection for the purpose of preliminary exam.
Identifications noted.
Thank you. And when you were having discussions with Mr. Jackson, did he indicate to you at any point that he knew she was pregnant?
Yes, in a roundabout way.
Can you explain that?
Yeah, at first he said no. He had no knowledge of her being pregnant. And then as I continued to speak with him, he said, well, she mentioned she might be pregnant several weeks ago or a month ago, but it wouldn't have been mine because she cheats on me all the time.
So he was acquiescing that she might be pregnant, but it would not be his.
He didn't seem to think it was legitimate
Okay.
and that she cheats on him. If she is pregnant, it's not his.
Okay.
That's the statement.
Now, did she indicate any type of weapons were used at that point? Okay. Did she indicate at any point that she felt scared of him or scared for her life, or?
Not that I recall specifically.
Did she indicate any time she felt scared that he might retaliate against her for making these reports?
Not explicitly, but she was pretty reluctant to give any information about the assault specifically. I think she knew the gravity of it, but that's pretty common in domestic violence situations where they want help, but they don't want to help getting help.
How many domestic violence, just in your estimate roundabout, you've responded to domestic violence cases before?
Oh, hundreds.
Okay. So you have a pretty good sense of the dynamics that go on here.
Yes.
Your Honor, I have what is people's proposed exhibit 1, 2, 3, and 4. I'm going to show these to defense counsel. Your Honor, if I could approach the witness.
You may.
I'm going to hand you what is people's proposed exhibit 1, officer. Could you please take a look at that? Is that accurate? Is that a photograph that was taken that day?
Yes.
And is that an accurate reflection of the state of the or the victim that day in the neck area?
It's not a great quality photo. I think it was worse in person, but yeah.
Okay. And where would you describe where those injuries are located?
In this exhibit, it's the front of her neck.
So you're pointing to this
Like
part
the
of the neck
throat.
right here?
Yeah.
Okay. And that led you to believe that her indication of him putting his hands around her neck were correct?
Yes.
Thank you. Your Honor, if I could approach.
Okay.
I'm going to hand you what is people's proposed exhibit 2. Would you please indicate what that photo is?
That is from.
Okay.
A little bit of bruising.
Okay. Could you indicate where that bruising happened or where it is on the picture?
I believe that is the left side of her neck.
So
Left or right?
coupled
No,
with
it's the right side.
the right side.
It's
So-
upside down.
Okay. So coupled with the first photo, there's bruising here on the throat and then bruising on the back right-hand side, I think you said. And would that lead you to believe that her indication that there was some type of strangulation, you think that leads you to believe that it's true?
Yes.
And Your Honor, approaching it.
Okay.
I'm going to hand you people's proposed exhibit 3. Could you please indicate to the court what that photograph is
A photo of the back of Morris's neck.
and what you see on the back of that photo?
There was some, I would call it abrasions or like that speckled kind of bruising at the
Okay.
beginning on the back of her neck and kind of extending down towards her upper back.
Now, let's be clear. You took these photos at the scene.
Yes.
Took you about 5 minutes to get there.
Yeah,
And how long was it before these photos were taken?
probably 10 more minutes.
Okay, so
20
15
more
minutes from the
minutes,
time you
maybe.
arrived or?
Yeah, I
you
think
seen
I was
the
only on scene a total of maybe 30 to 40 minutes, so.
So these photos weren't taken the next day when bruising had a chance to set in. These were immediate injuries.
Yeah, these were fresh, right away injuries.
And I have here what's called, what I'm going to title People's Proposed Exhibit 4. Could you please take a look at that? Could you please tell the court what that is?
This is a full back photo of Morris. There's a few bruises on her back and then a scratch on her shoulder.
Okay. And you said when you had contact with her, she was pretty beat up from head to toe.
Yeah.
Were there any other injuries to her body that you can recall?
Yeah, she had scrapes on her knee, she had a scrape on her foot. Her arms had bruising on them. Pretty much every limb of her had some mark on it.
So in your own words, she was pretty banged up.
Yes.
Your Honor, at this time, I would move to admit these exhibits as to the court.
Any objection to people's 1, 2, 3, 4?
No objection.
There,
And published under the court, Your Honor. Now, how long was your interaction at that time with Ms. Morris?
Like I said, I was there longer than 40 minutes total from the time of arrival to time of arrest, so.
You offered medical treatment to her that day?
Yeah.
Was medical treatment received that day?
To my knowledge, it was. Initially, when I offered it, she said no, but due to her pregnancy, I encouraged her a couple of times. The neighbor kind of took her in, one of the witnesses, and she said she was gonna try to convince her mom to take her, and I gave her my phone number, and I said, if she seeks treatment, will you call me and let me know? And then while I was writing my report.
Objection, Your Honor, hearsay.
Sorry about that.
objection sustained.
So the bottom line is you indicated to her she should get medical treatment.
Yes, and I was under the impression she did at some point.
You're not sure whether she did that or not.
Correct.
You had interactions, you said earlier, with Mr. Jackson.
Yes.
Did he say anything else to you? Did he admit to anything else besides the pregnancy?
No.
This time, I'm going to arrest you.
Okay, cross-examine?
Yes. Officer, start with your conversation with Mr. Jackson. You said that when you spoke with him about the pregnancy, your impression was he didn't believe she was pregnant at all, correct?
Yeah.
And-
Well, my impression was that he did know, but he was telling me he did not.
Okay. But he was telling you he didn't know she was pregnant, and if she was, it was probably somebody else's because she cheated, correct?
No, he mentioned that she had said it a few weeks prior. It's on,
That she may be pregnant,
yes.
but not that she was pregnant. He didn't tell you that he actually knew it or believed
Yes,
it.
correct.
Okay. As far as Ms. Morris, initially you said when you talked to her, her description of the assault was simply grabbed her arm and punched her, correct?
And she said that at some point she ended up on the ground. She wasn't sure where he had his hands, but she was on the ground.
Okay. And the statements regarding anything involving her neck only came out when you were asking her direct questions related to the lethality factors, correct?
Yes, when she said yes today, and then I asked her to elaborate.
Okay. And you asked her if she lost consciousness, correct?
Yes.
And she said she did not
She
lose
said she
consciousness.
did not.
And did you ask if she had any difficulty breathing?
Yes.
And she said she did not?
She said she couldn't remember.
She couldn't remember. Okay. But she didn't specifically say she had any difficulty breathing. And stated she did not see stars.
Correct.
She has abrasions and bruises and scratches on her neck. Is that correct? Ma'am?
Bruising mostly, but yes.
You said she was hesitant to give you any information, correct?
Yes, it's typical with victims of domestic violence.
But you weren't there when her and Mr. Jackson were interacting, correct?
No.
I have nothing for you.
Couple follow-up questions. Just to reiterate, you were there within 5 minutes,
Yes,
and you indicated earlier that her demeanor was, she was upset, crying. What else?
she had been crying. There was makeup was down her face. She was pretty shaky and upset.
So she was shaking it upset.
Is that a yes?
Yes.
Further questions?
Okay, any, this witness may be excused. Thank you. You can call your next witness.
This time, Your Honor, if people have no other witnesses.
Is the judge calling any witnesses today?
No witnesses this time.
Proceed to argument.
Yes. Thank you, Your Honor. At this time, defendant is charged with attempted assault with intent to rape on with harm, less than murder, and that attempt would be by strangulation. I think we have the officer who took the stand indicating she received a call to respond to that location. She was there within 5 minutes of receiving that call. When she got there, she came into contact with the alleged victim here, Ms. Morris. When she had contact with Ms. Morris, she seemed shaky, she was crying, she was upset, makeup was running. She indicated she could see visible injuries right off the bat when she got there. I think her testimony was Ms. Morris was pretty banged up from head to toe. There were photographs taken of the injuries at that time, which were submitted to the court. That would indicate injuries. At least 3 of those pictures showed there were injuries around the neck, the front of the neck, side of the neck, and the back of the neck, which led the officer to believe that when indicated she had been strangled, later on, the officer believed that just based on the nature of the injuries that she saw within 15 minutes, 10 minutes of arriving. You'll note there's major bruising on the back. There's an indication that indicated to the officer that she was pregnant at that time. She did indicate she would seek some type of medical treatment. The officer's not sure if she did see that or if she did seek that medical treatment. There's an indication from the officer that during the conversation, the victim, Mr. Jackson, had a child in common together, and also that they'd been in a former dating relationship. I think that indicates to the court that there is a domestic relationship between those two, as defined by the statute. I'm looking at the criminal jury instructions for assault, strangulation, or suffocation. Indicates first that the defendant committed a battery. The battery is an offensive touching, forceful, violent, or offensive touching of another person, something that something that's closely connected with that person. Clearly, the officer indicated that the victim said that she had received these injuries from the defendant, injuries around the neck, all the injuries is something that she indicated. I would find it highly unlikely that she acquiesced to have these injuries on her body, the bruising around the neck, on the back. I think the officer also indicated there were scrapes on the legs, feet, arms. And second, that touching must have been intended by the defendant. I don't think anyone can say that if someone's putting their hands around your neck and beating you up in a public area that they don't intend that touching to be offensive in some way. I find that highly unlikely that she would acquiesce to being beat up. Also, it cannot be accidental. There's no question of that here. It has to be injury that it has to be the touching that caused an injury. Clearly, Your Honor has photos. There's bruising around the neck, on the back. The officer indicated there was other bruising from the person. But the battery must have been committed by strangulation or suffocation. It's clear from looking at that photo that this person has bruising all around the neck, which would indicate this was caused by placing hands around the neck in a sufficiently strong, in a sufficiently powerful position to cause that bruising within 5 minutes. The officer said she noticed it right away when she got there. These photos are not from several days later when bruising really sets in. This is from right off the bat initially. I would indicate she did indicate that the witness did say that the hands were placed around her neck and she was strangled. Based on that, Your Honor, even though we have an attempted assault, I'm going to ask that this court increase that charge to the actual assault by strangulation. Also, there is a companion DV. I think that just goes along with it. I'm also going to ask this court also enter a charge of aggravated DV. I think Your Honor can see the pictures. They're aggravating injuries to this individual, which the officer was afraid would require medical treatment. Maybe the victim indicated she would receive medical treatment. Further, I'm going to ask that you amend this also up to assault with intent to do great bodily harm. We have a victim who was pregnant at the time. She indicated to the defendant several weeks earlier that she was pregnant. His indication was that it's not mine. Doesn't matter whose child it is. If she was medically with child at that time, physically with child, and received these injuries as we see them before the court today, I would ask you to add an additional count of assault with intent to do great bodily harm. Clearly, bodily harm was done just based on the pictures that we see.
Yes, Your Honor. First of all, as to the assault by strangulation or the request to up this to a charge of assault by strangulation, I'm going to focus that argument specifically on the third element, which is the battery was committed by strangulation or suffocation. Strangulation or suffocation means intentionally impeding the normal circulation of blood or breathing by applying pressure on the throat or neck or by blocking the nose or mouth. First of all, the testimony was that she said she never lost consciousness. She didn't have any difficulty breathing. And so there's no evidence that there was actually any impediment by anyone to her ability to breathe or the flow of blood through her neck. And so at best, this is an attempted assault by strangulation. However, I would ask the court not to bind over an assault by strangulation at all, as the entirety of the testimony in relation to that assault was that she asked, she asked him if he had ever put his hand on her neck. She said, yeah, today. That's the total extent of the injury. But there is no description as to what she meant by put her hands on her neck. That could be slapping her in the neck, that could be hitting her in the neck, that could be punching her in the throat. There was actually no testimony that she said he placed his hands around her neck and squeezed.
Doesn't that create a question of fact?
I don't think there's any evidence to create that question of fact.
Well, it does, because there's testimony that he put his hands around her neck, and the question is.
The testimony is not around her neck, it's on her neck.
On her neck.
And that's a
but
specific difference that I would argue does not meet the definition.
On or around, I think it's a bit of semantics. It doesn't be around, it just has to be on her neck in a manner in which that would impede normal circulation.
And there's no testimony that as to the manner in which hands were placed on a neck. And for assault by strangulation, the manner of contact between one individual and the other individual's neck has to be such that it could even even for an attempt, that it could even potentially cause a impediment to the flow of air or blood. And there's just no evidence as to what the contact was. At best, it's an attempt. And so I would specifically object to an increase, and I would ask the court not to bind over it. As to an aggravated domestic violence, there is no evidence that she required or sought medical treatment, simply that the officer thought she should, and that another person said that they would try to talk her into getting medical treatment. The officer was not sworn in as any sort of medical expert. There's no testimony as to whether or not the injuries, which are simply abrasions and scratches, would have been such that they required medical treatment. And so I would ask the court not add a charge of aggravated assault, although technically that's a misdemeanor, that there's not technically a right to a preliminary examination on. With regards to the request, to add an additional count of assault with intent to do great bodily harm less than murder, that requires that the defendant tried to physically injure another person, that at the time of the assault, the defendant had the ability to cause injury or belief he had the ability. And third, the defendant intended to cause great bodily injury. Great bodily injury means any physical injury that could seriously harm the health or function of the body. The injuries that we have are bruising, redness, abrasions, and some scratches. There are no broken bones. She was not bleeding. And so the injuries that there are pictures of that have been presented, I do not believe those injuries rise to the level of physical injury that could seriously harm the health or function of the body. Again, if the injuries to the neck reach that level, it is based on an argument there is an attempt to strangle or suffocate, not a separate crime. The rest of the injuries of the body, superficial bruising to the body, is not a great bodily harm. Nothing beyond this allegation that there was an attempted suffocation that would lead to great bodily injury. I would ask the court at most bind over on the simple one count of attempted assault by strangulation. Thank you.
Thank you, Your Honor. I think defense counsel's own argument about prong 3 of the test, that has to be cut off the airflow or impede the blood supply. Clearly, when you're looking at the pictures, there's bruising around the neck. It's caused by some type of action around the neck, which you don't get blood bruising without impeding somehow the flow of blood to a certain area. So I would indicate that I think there's sufficient evidence to meet the standard probable cause for that. In terms of the assault intent to do great bodily harm, I would indicate She was pregnant. She was assaulted when pregnant. I don't think that it actually requires that there be broken bones, as was indicated by defense counsel, to make that charge. Clearly, these are very serious injuries. When I'm looking at the picture, I see a bruise on her back that looks like it's about the size of a baseball. That seems to be a pretty significant injury. I'm seeing bruising all around the neck, and this is right after this assault happened. I'm seeing it on the side of the neck and on the back of the neck. Again, that would lead a reasonable person to make an inference that hands were placed around this neck, strangulation happened, which caused impeding of the blood flow, which caused bruising and scrapes around the neck. So I'm going to ask you to find it over on all the counts that I requested. I think there's sufficient information to report on this. This is a preliminary exam where probable cause is the standard.
Thank you. Date is the date for the preliminary examination, and as indicated by prosecution in this re-argument, the burden is on the prosecution to only establish probable cause. So that's more than mere suspicion that the crimes were committed, and more than mere suspicion that you were the person that committed the crimes. They do not need to prove each element beyond a reasonable doubt at this stage. And any issues that were questions of fact that result from today's hearing are best resolved at the trial court on this particular case. We have count one, attempted assault with intent to do great bodily harm, less than murder, or by strangulation. We heard testimony today from Officer Tara Brandman. She testified that she reported to the scene of Cesar Chavez at on her Chestnut on June 14, 2023. That area being in the city of Lansing, Ingham County, state of Michigan, not making venue in this court appropriate. As she stated, she reported in response to a call that a male was assaulting a female, and that she came in contact with the victim, or the alleged victim, Alyssa Morris, who was very upset. She was crying, her mascara was running down her face. The officer testified that she personally observed visible injuries all over the victim's body. She stated that the victim seemed pretty banged up, that there was bruising from head to toe, or injuries observed from head to toe. She testified that the victim stated that the parties were in a former dating relationship, that they shared one child in common, but that the victim was currently pregnant with a second child with the defendant. She did identify, the witness did identify the defendant in court as the person alleged to have been the subject in this matter. That the victim testified that they got into a heated argument about childcare or assisting with the child, and that the defendant became physical and he repeatedly punched her. The officer observed marks around the victim's neck. The officer questioned, and the officer did testify that she found the witness or the victim to be or to not be forthcoming or reluctant to share information. But as the investigation continued, the officer questioned particularly whether or not the defendant had ever put his hands around the victim's neck. The officer testified that being her actual question, has he ever put his hands around your neck? So I wrote that down, and the response was yes today. So it was his hands on the neck, but was it around is what she testified to. Even if it was on, the concern or question that's before the court is whether or not there's probable cause as to the elements as alleged. And to prove attempted assault by strangulation, again, the people would need to prove at trial beyond a reasonable doubt. First, the defendant committed a battery or attempted to commit a battery, which is a forceful, violent, offensive touching of another or something closely connected with the person. Again, I think that's without question, because as alleged, there was a altercation in which the victim reported that the defendant became physical with her and punched her multiple times, and that this altercation resulted in what the officer termed as being pretty banged up, bruises from head to toe. Second, that the touching must have been intended by the defendant, that is not accidental, and must have been against the victim's will. It does not matter whether the touching caused an injury. I think it's undisputed that we have sufficient probable cause as to that element. Third, that the battery was committed by strangulation or suffocation. Strangulation or suffocation means impeding normal circulation of the blood or breathing by applying pressure on the throat or neck, or by blocking the nose or throat. Although I believe that the testimony was clear that when the officer asked, does he ever put his hands around your neck? And she said, yes, today. Well, that gives enough probable cause that his hands was placed around the victim's neck. I look at the pictures here, mainly People's Exhibit 1 shows some redness or bruising around the victim's neck. People's 3 show bruising around the back of the neck. And then also People's 2 also indicating some bruising around the neck. And again, there's testimony that the hands was placed around the victim's neck. This bruising that I see in the picture, and an officer did testify that this is not the best reflection of what she observed. She believed the injuries to be much worse in person, and that she doesn't think this is a good copy. But nonetheless, even based off what I view in this exhibit, it's apparent to the court that there was some physical touch that took place that impeded the circulation in her neck, which causing the bruising to the neck. And so with that being stated, I think there's sufficient probable cause as to count 1 as charged, which is attempted assault by strangulation. Then the people are requesting to add additional count. That'd be count 2 of assault with intent to do great bodily harm. Yes, I said, and meant to add count 2 of assault with intent to do great bodily harm, less than murder or by strangulation. And the argument by the people is that there was sufficient or severe injury. There's a People's Exhibit 4 that does show a bruising to the back. I see multiple areas that appear to be black or dark discolored on the back. There is one area on the right side that is about the size of a baseball. And then I would say one a little bit smaller than a golf ball on the other side. And it looks like there's some scratching and bruising on the victim being pregnant at the time of the incident. And then the description given by the officer who observed is that there was bruising and abrasions throughout the victim's body. She observed from head to toe. She stated that she believed the victim to be pretty banged up and was concerned, especially considering that she's pregnant, about her need for medical treatment. We had no testimony or evidence that would demonstrate one way or another whether or not there was a broken bone, but a broken bone is not the only element or the only way to satisfy the elements. And today it's a probable cause standard. And so at trial, they would need to prove that the defendant tried to physically injure another person. Well, we have clear testimony here as to that. Second, that at the time of the assault, the defendant had the ability to cause an injury or believe that he had the ability. The testimony supported by Officer Brandman and the testimony or the exhibits that were admitted would support a probable cause finding as to the second element. Third, that the defendant intended to cause great bodily harm. Actual injury is not necessary, but if there is injury, you may consider it as evidence in deciding whether the defendant intended to cause great bodily harm. Great bodily harm means any physical injury that could seriously harm the health or function of the body. And the allegation is that there was a physical altercation or assault that upon a pregnant person in which she allegedly was strangled and allegedly punched multiple times and other injury being caused throughout her body. Again, injury not even being necessary as an element. The court is satisfied that there's sufficient probable cause as to add the requested count 2 for assault with intent to do great bodily harm. The people are requesting to add a count 3 of aggravated domestic violence that does not require a probable cause finding, so that motion will be granted. Each matter will be bound over to the circuit court for a bind over date August 2nd. You do not need to appear in court on August 2nd. That's the date that the circuit court gets the file from this court. Your next court date will be in circuit court, but it'll be a pretrial. You're responsible to make sure that they have that we have an accurate address and contact information for you in order to make sure you're getting your court dates. You stay in contact with your attorney. I have an address here for Hosmer. Is that where you live?
Yes, ma'am.
Okay. Phone number ending, there's 2 phone numbers. There's an 8533 and there's a 7830.
783. I mean the 704. It ends in 30, 7830. That's the best one. 517-204.
7830 is the best one. Okay. Okay. Your attorney will be made aware of your next court date. As it relates to bond was set at 3,510%. There was a PA 53 violation, but obviously we don't have a victim here. I did review the report. I have a concern about the bond. I'm going to address the bond.
Address that.
Okay, did you want to add anything or state something?
Just, I wanted to indicate, obviously, the testimony the first day was pretty graphic, pictures are pretty graphic. There is an alleged PA 53 violation. Obviously, I don't have a witness here to testify to that today, but it would lead the court to indicate there may be some possible contact and additional assaults going on. I would ask for, and if it is not, I don't know already, that a tether be added to conditions of the bond with notification to the victim. I will leave, if you want to up the monetary amount of the bond up to the court and handle a lot of these cases. So I just, in this case, it's appropriate to have a tether.
Counsel.
I would ask that no modifications be made to Mr. Jackson's bond. He appeared today in court. There's been no actual evidence presented to the court that he hasn't been in violation of any of the conditions of his bond. Don't see any reason to add a tether. I certainly don't see any reason to increase the amount of his bond.
Oh.
He is also, in my understanding, in contact with pretrial services and complying with all other conditions.
That's good. I'm glad that he's in contact with pretrial services. However, bond was set at 3,510%. He was notified that it could only be third-party contact regarding the minor child. There was an allegation, although we did not have a witness here, that there was a violation of that. There was also an allegation of further contact and that the defendant might have been residing or staying at the alleged victim's house, but that resulted in additional assault. We don't have testimony about that, but considering even just the mere allegation, and then we have additional counts added here today of assault with the intent to do great bodily harm and aggravated domestic violence. I think it's appropriate that a GPS tether requirement be added. I will add GPS tether. He will be remanded to get GPS tether today, and then he can be released on his previous bond with the GPS tether and with victim notification. You're not to be at the address of 420 West Cesar Chavez. You're not to be within 1,500 feet of 420 West Cesar Chavez. Do you understand that? I can hear you.
I see, yes, ma'am.
Okay, do you have any questions about your bond condition?
No, ma'am.
Okay.
I mean, so it's just tether, right?
You're just getting a tether. Okay, any
Do I have
additional?
to pay for it or anything?
You are required to pay, but you may be able to get some assistance. You can talk to your counsel about whether or not you're eligible for that, okay? Any additional matters?
Nothing further from the people. Your Honor.
Nothing further from the defense, Your Honor.
You're all sorry.
Mr. Sark is here. I'm going to talk to him briefly.
I just wanted to apologize, Your Honor. It's been one of those ones.
Oh, you're fine. I heard you were in another court.
Yes. I had 4 prelims for them this morning. 4 judge.
I think,
Thank you. Not all 4 of them ran, but still, I had 4 on the docket. So, again, my apologies.
you're fine. Thank you.
Yeah.
That's an action, GPS, and GPS is supposed to be reflected application.